session. The Honorable Judge Michael Nobles presiding.
All right, please be seated. You ready?
I'm ready.
All right, we are here on cause number 2322, CR 00297-01, State of Missouri versus Daniel Riley. Mr. Riley is present with his attorney, Dan Deemer, and the state is present by Tanya Engelhardt, So this matter is before for sentencing pursuant to the verdict which was rendered by the jury finding the defendant guilty under count 1 of assault in the second, count 2 armed criminal action, count 3 assault fourth, and count 5 operating a vehicle without a license. The court has reviewed the motion for a new trial. Is there anything further that Mr. Deemer, you want to put on the record regarding the motion for a new trial?
No, I believe it's supported by the record and unrefuted by any pleadings filed by the state.
All right. The court will deny the motion for a new trial. The court has received the sentencing assessment report. Are there any edits or additions that either party would like to add to the sentencing assessment report? Mr. Deemer?
No, sir.
State? All right. I see the victim is present with her family. State, you may proceed if there's any victim impact that you'd like to share with the court.
Yes, Your Honor. Would you like the victim impact statement first?
Yes, please. All right, if you would address your comments to me and not to Mr. Riley, please.
We're going to do one statement for all of us.
Okay.
On February 18th, 2023, Janae was hit by a car that Daniel Riley was driving as we left our volleyball tournament. On that day, Daniel Riley chose to focus on his own personal satisfactions rather than showing consideration for humanity as he drove down the street. On that night, Janae endured so much physical trauma. She was seconds from dying right there in front of us on the street. Her legs were completely severed and she was bleeding out. But she fought, and we fought. Her will to live was far greater than what Daniel Riley could do to her. When we got to the hospital that night, we told her she had to fight harder than she had ever had to fight for anything in her life. While she had already been intubated, she squeezed our hand to let us know she heard us and to let us know she would fight. She is strong beyond any measure. For our family, if we had lost her that night, I don't know how any of us would ever made it through. Since that day, our lives has been so drastically altered. Not only our lives were impacted, but so many other people in her life. Her sisters, her brothers, her nieces, her nephews, her people in our extended family, Janae's friends that she grew up with, her teammates, her coaches, our entire community, the volleyball community. When you see her smile, it hides her sadness. It hides her physical pain. And it hides a lot of emotional pain that she has. During the past 2 years and 2 months, she has had to endure so much, and she always tried to smile and be positive through it. That's a test to her character. She doesn't complain about things. Why does she do this? Because she knows her unhappiness would be far too great of a burden for us and the rest of her family. She takes on her own pain and she hides it so that people that she loves don't hurt. Her laughter and her smile is what has carried us through this entire ordeal. And it's carried so many other people too. Janae's resilience, compassion, and determination in the face of adversity will always serve as a reminder of how strong of a person she is to be able to overcome what she's had to so far. She still has so much more to endure in her life as we do. She will face it head on because that's who she is. We are still working toward finding a new normal for our family. We also know and want to say that God has carried us during this time, and we give him all that praise because without him we wouldn't have made it. And we know he will be there going forward. Since our children were little, we've always taught them their actions have consequences, good or bad. Daniel Riley has never had any consequences for any of his actions. He doesn't know the meaning of that word. He has shown no compassion during any of this entire ordeal. He has shown no remorse, no empathy, because he don't have it in him. It's not in his soul. Compassion comes from being held accountable to higher standards. He's never been held accountable before for anything in his life. He has demonstrated over and over during this trial and during this past year that he has no concern for humanity and no concern for the harm that he did to our daughter. If he did, he would have shown it. We ask this court to make Daniel Riley accountable for his actions. He must face the full extent of the consequences to what he has done to Janae on that date, February 18th. He needs to serve the entire sentence as the jury gave, and we ask on behalf of our family that he serve each individual sentence consecutively. Based on his own actions, he sentenced Janae on that street that night to be an amputee for the rest of her life. The sentence he was given will never be enough to repay for what she had taken from her and from our family. He deserves the sentence that he was given to be served in its entirety and consecutively. We beg that you will honor that. Thank you.
Thank you. Is there anyone else from the state?
No, Your Honor.
Does the state have a recommendation?
Yes, Your Honor. I just wanted to remark about how deliberate the jury was, both in rendering their verdicts and in determining their sentencing recommendation. It's difficult sometimes to get 12 people to agree on anything, but based on the lengths of their deliberations, they were able to get together, and together as a unit representing the people of the city of St. Louis gave the recommendations for each count. Your Honor, I believe that those sentences should also run consecutive. I know that the armed criminal action and the assault second must be run consecutively by statute, but just following the intention and the will of the jury, of the people, I ask the court to also run the sentence on the assault 4th degree consecutive as well, and to impose the maximum fine on the driving without a valid license.
Thank you. Mr. Deemer?
Judge, one matter that if we could approach.
Sure. Mr. Deemer, do you have anything to share with the court?
No, sir.
Does Mr. Riley have anything he wants to share with the court?
No, sir.
Okay. During the penalty phase of this trial, the jury, which was made up of 12 dutiful residents of the city of St. Louis, in my opinion, spoke loud and clear. If you drive without a license and recklessly injure someone in the streets in the city of St. Louis, that the consequences will be severe. The jury declared the punishment for counts 1, 2, and 3 after considering the mitigation evidence provided by the defense, the impact of the offense upon Ms. Edmondson and her family, the nature and circumstances of the offense, as well as the history and the character of the defendant. The jury's recommendation as to punishment is not binding upon this court. It does act as a ceiling on the sentence that I may impose, but it also gives discretion to the court to reduce the punishment recommended by the jury. In this case, the court cannot find any grounds to disturb the recommendation made by the jury, as the verdict represents the judgment of the community as to the appropriate punishment in this case. However, the determination of punishment for count 5 and how the time is to run is the duty of the court. The jury found that this was not an accident. Mr. Riley, you were responsible for your choices from the moment you walked out of your home into that rental car. You chose not to have a valid driver's license for 5 years, which means you chose not to properly learn how to drive a car, which is a dangerous instrument readily capable of causing serious physical injury, as we have seen. You chose to violate the conditions of your house arrest, and you chose to drive that dangerous instrument recklessly. Those choices have consequence. So as to count 1, the defendant is sentenced to 6 years, 3 months in the Missouri Department of Corrections. As to count 2, 11 years, 8 months in Missouri Department of Correction. And as to count 3, 10 months in the Justice Center. As to count 5, the court imposes the maximum fine of $500. All the counts are to run consecutive for a total of 18 years and 9 months. Mr. Riley, you have certain rights under the law of Missouri after a person is convicted of a felony after a trial. Certain rights apply to the review of the legality of the conviction. In addition to the right of appeal, you have the right to file a motion under certain rules of the Missouri Supreme Court. The rule that applies to you is 29.15. This rule provides you with the right to file a motion in this court to vacate, set aside, or correct the judgment of conviction or sentence. And by asking for a review under that rule, you're entitled to have the court decide first whether the judgment of conviction or sentence violated the laws or constitutions of the United States or the state of Missouri. 2, whether this court had the jurisdiction to convict you. And 3, whether the sentence imposed was in excess of the maximum sentence authorized by law. In order to obtain a review of your conviction under 29.15, you must file criminal procedure form number 40, and you must do so within 6 months. Failure to file that motion within that time limit will result in a complete waiver of any right you may have to ask relief under that rule. If you file this motion, you must include every ground known to you for vacating, setting aside, or correcting the judgment or sentence. And if you file such a motion and cannot afford an attorney, a new attorney will be appointed to represent you free of charge. Do you believe you understand your rights to proceed under 29.15?
Yes.
Do you have any questions about this procedure for me or your attorney?
No.
Next, it's my duty to ask you questions regarding your attorney in this case. I'm going to ask you questions about your dealings with your attorney. In doing so, I'm asking to find out whether he lived up to what we consider to be reasonable professional standards. Mr. Deemer can either be present in the courtroom or I can ask him to step out in the hall.
He can be present.
All right. Mr. Deemer, he was your attorney in this case, correct?
Yes, sir.
How many times did he talk to you regarding this particular case, roughly?
Several times.
More than 10, I'm guessing?
Yeah.
All right. So did he go over the police report?
Yes.
Did he go over the good parts?
Yes.
Bad parts?
Yes.
At some point, in looking in the case, you and Mr. Deemer decided that you wanted to take this to trial. Is that correct?
Yes.
You knew you had an option of taking a plea. Is that my understanding that there was a plea offer on the table?
Yes.
It's my understanding that after talking to Mr. Deemer, you rejected that. Is that correct?
Yes. That's
All right. So you decided to go to trial. Did you and Mr. Deemer work on that trial together? By that, do I mean, did he tell you what his plans were and how he was planning on putting on a defense?
Yeah,
All right, did he go over different witnesses he was possibly going to call?
yeah,
All right, so there were several decisions during that trial. One mainly, we talked about it on the trial, was regarding whether you were going to testify or not. Do you remember that?
yes,
All right, so the court asked you about that, and you said that after talking with Mr. Deemer, you had decided that you did not want to testify. Is that correct?
yes,
But you, ultimately, it was your decision, but you ran that decision by Mr. Deemer.
correct,
Okay. And also during the punishment phase, you were given an opportunity to talk, and again, you decided not to. Is that correct?
correct,
And that was after you consulting with Mr. Deemer as well?
correct.
Okay. Do you have any complaints about the way Mr. Deemer has handled your case? I know you're not happy about the outcome, but is there any issues with the way he's handled the case?
I mean, I won't really know until I hire another attorney.
Okay, but as of right now, you can't articulate any issues or problems you've had with Mr. Deemer?
No, sir.
Okay. Let me back up the one thing. When the state had made you an offer and you had decided to go to trial, did Mr. Deemer go over the full range of punishment? In other words, you could end up with not guilty, but you could also end up with the maximum sentence?
Yes, he did.
He did go over that with you? Okay. All right. All right, following the examination of the defendant pursuant to 2907B4, the court finds that the defendant has been advised of his rights to proceed under 29.15, and the defendant understands those rights. He was represented at all critical stages of this proceeding by Mr. Dan Deemer. Mr. Deemer investigated the case. He advised the defendant concerning all significant aspects of the case, informed the defendant of the trial and trial preparations, and prepared him for trial and represented him at the trial in a reasonably competent professional manner. The court finds and concludes that there is no probable cause to believe he has received ineffective assistance of counsel and will continue to rep him to the extent necessary. Is there anything before we go off the record?
Your Honor, I will file a notice of appeal. I do have an order to proceed in form of paupers from Mr. Riley since he's confined.
All right, if you'd have him sign his portion, and the court will sign that. Anything from the state?
No, Your Honor.
All right, this concludes the matter on the record. We're at temporary recess.
All rise. Court is in recess.